The NCLT has reserved its orders on a plea filed by cash-strapped airline Go First. The airline is filed for bankruptcy protection and is seeking protection under an interim moratorium. Aircraft lessors to Go First rejected the petition, arguing that a moratorium will stop third parties from enforcing their contractual rights. Meanwhile, Go First has also cancelled flights till the 9th of May. Aviation regulator DGC has ordered a full refund to all passengers. The CEO of Go First spoke to CNBC-TV18 yesterday and said that bookings have been suspended from the 6th of May to the 15th of May. Go First blames its engine supplier Pratt & Whitney of defying a Singapore arbitration order and supplying engines. It is suing the engine maker in a US court in Delaware. Ashmit joins us now with more on what transpired at the NCLT, the order being reserved, Ashmit, the interim moratorium being sought there by Go First creditors opposing that, and the NCLT also asking relevant questions that if Pratt & Whitney hasn't been able to deliver the engines so far, what good will a moratorium do?
Indeed, the argument stretched across nearly 4 hours. The contention that is being put forth by Go Air is that, look, the entire idea of the IBC is to preserve the company in question, to make sure that it is maintained as a going concern. And with that in mind, they have sought the protection of an interim moratorium. What they're essentially arguing is that if this moratorium is not allowed, then the lessors will have a free hand in taking possession back of the aircraft, which would leave nothing for the airline. They, in fact, at one point also cited the example of Jet, which at the time of going into insolvency had over 100 aircraft. But by the time the resolution applicant came into the picture, it had come down to as low as 11. So that's the rationale, that's the example that Go Air gave in trying to seek some relief from the NCLT. The NCLT on its part had some pointed questions to ask. Number one, the NCLT asked that whether or not there is any power available under the IBC to allow for such an interim moratorium. The second question they asked is that as far as the aircraft themselves are concerned, if there are issues of maintenance and supply of engines, then there's a very real concern that the balanced 26 aircraft could also be grounded, and therefore the question arises, is there a need for a moratorium? Another question that was posed by the NCLT is that the company has been professionally run. What addition can an IRP make to the running of the company that the current promoter and the current management could not make? So these were some pointed questions. Now, what is also important at this point to understand is that the lessors, as representing as many as 26 aircraft, were here before. They're objecting to Go Air's application. They're saying that this is a malicious litigation, and they're objecting to grant of any relief, claiming that they have contractual rights to terminate the lease agreement and to take the aircraft back. So on all of these questions, we understand the orders have been reserved, and the NCLT will have the final word on how to proceed, whether or not to allow this interim moratorium or to have the lessors with a free hand to take back the aircraft.
Well, Ashmit, many thanks for joining us. If the lessors get to take back the aircraft, then there is no resolution plan that can be put in place. And even as Go Air finds itself in trouble, another low-cost carrier is eyeing expansion. SpiceJet is planning to revive its grounded fleet in the next 2 to 3